Today, the International Tribunal for the Law of the Sea in Hamburg is in the process of ruling in the case of Ukrainian sailors who were captured by Russian forces. On April 16th, Ukraine submitted a request for prescription of provisional measures against Russia. The submissions include a call for the release of the vessels and the 24 servicemen. Russia is attempting to use a military activities exception in its case. Marny Chik, one of Ukraine's representatives, has dismantled this claim. Let's take a listen.
Russia itself has repeatedly and consistently insisted that its actions are law enforcement, not military activities. Article 298 draws a clear distinction between law enforcement activities on the one hand and military activities on the other. Russia characterizes its own conduct as falling in the law enforcement category. Prior Annex 7 tribunals applying the convention have correctly concluded that the military activities exception cannot apply when the party whose actions are at issue has characterized its own actions as non-military in nature.
Furthermore, the Russian Federation expressly stated that the aforementioned procedures are not accepted with respect to disputes concerning military activities by government vessels and aircraft. For this obvious reason, the Russian Federation is of the view that there is no basis for the International Tribunal for the Law of the Sea to rule on the issue of the provisional measures requested by Ukraine, and of quote,
In the same note verbal, the Federation of Russia informed the tribunal,
I quote, of its decision not to participate in the hearing on provisional measures in the case initiated by Ukraine.
The essential facts of this case are not in dispute. On the 23rd of November 2018, on the 25th of November 2018, two small Ukrainian warships, the Berdiansk and the Nikopol, and a naval auxiliary vessel, a tugboat named the Yany Kаpu, were seized and detained by ships of the Russian Coast Guard. The seizure took place in the Black Sea to the south and west of the entrance to the Kerch Strait. The relevant maritime area is shown on the map at page 1 of the slide deck and now on the screens. A report published by Russia's Federal Security Service, the FSB, records that the Ukrainian vessels were in the Black Sea and traveling away from the Crimean coastline at the time of the seizure.
With your permission, I will now introduce Ukraine's case. The dispute between the parties concerns the Russian Federation's unlawful and continuing seizure and detention of the Ukrainian warships Berdiansk and Nikopol and Ukrainian naval vessel Yany Kаpu on the 25th of November 2018 in the Black Sea. It is not just the ships that have been detained, but also the 24 Ukrainian servicemen on board. As a result of seizure and detention, Russia has violated the basic principle of the immunity of the warship under the United Nations Convention on the Law of the Sea. Ukraine has instituted an arbitration under Annex 7 of the Convention and seek relief for this violation. We appear before this tribunal today to ask you to exercise your power under the Convention to prescribe provisional measures when the urgency of the situation so requires. Mr. President, members of the Tribunal, Ukraine's naval ships continue to be held by Russia 6 months after they were seized, and the servicemen are under investigation and are detained in Lefortovo prison in Moscow. These servicemen are charged with the criminal offense, violating the border of the Russian Federation. They are now under pretrial investigation. Their detention has been renewed twice by Russia's courts. The second time was only 3 weeks ago, 2 days after Ukraine submitted its request for provisional measures before this tribunal. This is just an additional illustration of Russia's continuing disrespect for international law. From the moment of the detentions, Ukraine has worked urgently to solve this matter. In keeping with Article 33 of the United Nations Charter, we gave Russia every opportunity to settle the issue by diplomatic means. We have worked through a variety of international fora to persuade Russia to respect its international obligations. But having made no progress, after several months of such efforts, and instead facing the detention of our servicemen being extended, we finally had no choice but to turn to judicial means of dispute resolution. Russia has ignored not only Ukraine's requests, but also numerous calls by international community, insisting that its actions are justified under its domestic law and under United Nations Convention of Law of the Sea. And now, Russia seeks to escape scrutiny of its unlawful actions by asking this tribunal to treat them as military activities, exempt from compulsory dispute settlement under the Convention, even though Russia has previously insisted that the events of 25th November were not a military confrontation. In fact, Russia's conduct constitutes a profound violation of the Convention and customary international law. Let me be clear. There is no question that Crimea is part of Ukraine and that the waters in which the seizure occurred constitute Ukraine's territorial sea or exclusive economic zone. But Russia's actions would violate Convention even if they had occurred in Russia's territorial sea or exclusive economic zone. The immunity of warships is the core sovereign immunity in the international system. Warships and their personnel can't be arrested by the law enforcement authorities of foreign state and subjected to the jurisdiction of foreign courts. Ukraine has come before this tribunal seeking urgent relief from ongoing harm under Articles 32, 58, 95, and 96 of the Convention and under customary principles of international law. Each additional day of detentions, each interrogation, each court appearance aggravates the dispute between the parties. This tribunal has previously said that a warship is the very, and here I quote, expression of the sovereignty of the state whose flag it flies, end of quote. And it has recognized that each day a warship is detained results in material and irreparable harm to the legal and practical interest of the flag state. As for the servicemen, this tribunal has more than once observed that, and here I quote, considerations of humanity must apply in the law of the sea as they do in other areas of international law, end of quote. Here, such principles require an immediate end to the separation of Ukraine's 24 servicemen from their families and their homes. The harm imposed on Ukraine, its naval vessels, and its servicemen is grave and grows with every day that passes. The situation is therefore exceptionally urgent. That is why Ukraine today asks the tribunal to grant provisional measures requiring that Russia promptly release Ukraine's naval vessels and its servicemen and return them to Ukraine.